Our last case of the morning is People versus Enciso. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it up, and we ask that you do your best to keep track of your own time. And you have 2 minutes of a free fire zone. Please begin when you're ready.
Good morning, Your Honors. Mike Mittlestat of the State Appellate Defender's Office, back here again on behalf of Mr. Enciso. I think it's Mr. Enciso.
Enciso, thank you.
I'm quite clear on that. I would like to reserve 2 minutes of my time for rebuttal, and I'll try to do a better job than I did yesterday in keeping my own time there. So, on that point too, I will waive my fire-free zone because I know that there's a lot of sort of divergent issues here and a lot possibly to talk about. So I'll let the court direct me as to whatever concerns they may have at the primary there. But we're submitting that at the very least, Mr. Enciso and defendants like him should be entitled to relief under People versus Davis. I understand that courts have held that discrete and singular violations of the right to physical presence can be subject to harmless error review, but this case is different. This involves a defendant's physical removal from the courtroom for an entire proceeding from start to end. It is a pervasive error, it is a structural error, it is a framework error. It's similar to the error identified in Waller versus Georgia, which was the predecessor to Presley versus Georgia, in that the right to a public proceeding was violated during a suppression hearing, pretrial suppression hearing. So it happened during a proceeding that reached its conclusion, started and ended, and it was a pervasive to that particular proceeding. I understand it's not pervasive to the whole entire trial or plea process in this case, but it was pervasive with regard to sentencing.
Counsel, good morning. Just a question for you. What do you think would happen if we were to redo this? Do you think it could lead to a different outcome, or what would the ultimate end game be on this?
A couple of things. It would lead to a process that was both fair in fact and fair in appearance, and possibly lead to a different outcome. Because as we've briefed extensively, the right to physical presence serves goals beyond merely just trying to figure out what the right sentence it is. There's the right to personally participate in the proceeding at which the defendant is the primary focus. There is the importance of physical presence with regard to the interaction between the judge and the victims and the public that is fulfilled by the right to physical presence. There is the right of meaningful allocution, which this court has held, and a defendant is entitled to relief even when there is a limited amount of discretion afforded to the sentencing judge. If the right to allocution is watered down or prevented, that we reverse on that front. So on that, we would achieve a fair result in fact and a fairer result in appearance. Now, I would contend that there is a significant possibility that we would achieve a better result with regard to the sentencing too, but for purposes of our argument, that's not really relevant. But I can talk to the harm that comes from a defendant being removed from the courtroom and being required to participate from a remote location. The harm that to his ability to allocute, the harm to his ability to have ongoing consultation with his lawyer. And all sides seem to agree with People versus Heller that video interaction waters down the proceedings. Now, the question is, does that prevent it from becoming a structural error? And our submission is no, because there is a significant psychological impact on the judge from having the defendant personally present. Judges are human just like you and me. Judges they respond to different things, and we know that video interaction changes the dynamics of a sentencing hearing.
Why should we treat this as a structural error when the federal courts don't?
Well, I'm not sure that the federal courts have really dealt with, well, they have in terms of, but most of them have dealt with it in terms of violations of, number one, the CARES Act, or post-COVID, where a different analysis comes into play, right? Where we talk about the balancing of the emergency situation of COVID and things like that. But when the denial of physical presence is not related to some sort of emergency, I would submit a different analysis would play. Now, the federal courts have focused on primarily discrete violations, like the Russian case we cited, where the defendant was deprived of his right to presence during a in-camera hearing with the jurors. I don't think there's Supreme Court, U.S. Supreme Court has ever held that the complete denial of the right to physical presence for an entire sentencing hearing is or is not subject to structural error analysis.
When you look at what we view as structural errors, tell me how you think this one rises to that.
Yeah. Now, this court in Davis and the U.S. Supreme Court in Weaver talked about sort of the three aspects of structural error that are common why we have a structural error. I've talked about one with Justice Bernstein, but I'll reiterate it. Again, I'll go over the three. Does the rule that is violated protect interests that go beyond the search for the truth and accurate results? Is it difficult or impossible to assess harm on appeal? And does the rule violation often or usually result in fundamental unfairness? I think all of those are present here. Again, I talked about the need for the defendant to personally participate, not just for the defendant himself, although that is very important, but for the victims. Now, victims have complained about the defendant not being present when they've allocuted, and so there's victims' interest there too.
What specific facts in this case can you point to that you would argue that the sentence could have been less?
What specific facts that the sentence? Well, he got the judge exercises his discretion in two key ways. He went to the top of the guidelines or near the top of the guidelines for both offenses, and he exercises his discretion to impose consecutive sentences.
But he could have done that in person.
He could have done that in person.
So was there anything specific that you can point to that you feel that had this been in person, the sentence could have been less? Or maybe that's part of the argument of why
that's exactly
why
my
it's
argument.
difficult to. Okay.
That's exactly my argument. Is I can't point to everything that could have been different had this been an in-person hearing. I'll freely admit that, and that is the essence of a structural error.
Well, but let me push you on that. You were here arguing Yarborough yesterday, is that right?
Yes.
Okay, so, and we had that discussion of how do you prove harmlessness, right, in the refusal to allow counsel to excuse peremptory, right? Like, and I think actually both sides were like, I don't think you can, right?
Yeah.
Here, I mean, you could have technical there is a way to show error, right? That, he was trying to talk to his attorney and they weren't, it was clear that they weren't allowing it. Okay, so you could maybe prove harmless error that way. His audio wasn't working, and so the judge is like, well, you're not saying anything. It must be you don't have anything to say. Well, it turns out his audio was off. I mean, if there is a way to establish harmless error, isn't that different than this sort of, going to the second point of why it's structural, sort of contrasting it with Yarborough where it's hard to point that out, or impossible maybe in Yarborough.
I'm glad you started out that question with saying you can look for error, because there's a distinction between error and harm. You can look at the record for error, but you can't look at the record to see the whole vast variety of harm that arises from the defendant not being there. That includes the psychological impact on the sentencer of having the defendant in the same room as the judge when he pronounces sentence. Courts have determined and made it clear that that's a very important, intensely human process. Right? I analogize it. I know there's not a right to confrontation at sentencing, but some of the analysis that does apply to the confrontation clause, specifically Coy versus the Coy case.
Your point is it's hard to look somebody in the eye and send them off to prison.
Exactly.
The distinction you're making, I think, is important, but I guess I'm not sure about errors and harms as much as it is between the harms that can be seen and the harms that are really sort of unseen, right? And so the harms that can be seen and are obvious are technical difficulties. That's one. Another harm, I think, in your case, would be that the lawyer is not is distant from the client. There's a lot of different dynamics at play here. So if the lawyer was with the defendant in jail, maybe at least you'd have an ability to consult your lawyer during the court hearing. But here we don't have that. You have a distance between and an inability to communicate in real time with the lawyer. But the other in addition to communication, and I think it's very real, by the way, this notion of a judge looking somebody in the eye. I think the judge doesn't do anything more significant in their entire career than each time they deprive a person of their liberty. And they should have to look that person in the eye. And by the way, the victim should have the opportunity to look the defendant in the eye. And that's why I've argued so vigorously in favor of in-court hearings for anything meaningful that happens in court. But I think there's one other, and there's a lot of ways. It's hard to capture all the different dynamics that go on in a court hearing. But here we are in court today, and there's one thing that is noteworthy. You're the center of attention. We're all focusing on you and listening to you. And that's what happens in trial courts every day. But when somebody has their hearing remotely, and people are in different places doing different things, and their lawyer has 3 or 4 hearings that morning and is driving in their car and zooming into court, and the judge is at his or her cottage wearing their Birkenstocks, and the defendant's in the prison trying to get the technical equipment that the jail can't even afford to provide working properly, what we don't have is the defendant or whatever the matter in court is at that moment being the center of everybody's attention at that time. And to me, that's a real structural problem with what we have done to the court system. And I'd like to hear your view on that.
Well, first of all, Justice Viviano, you had me at hello there. So.
Hey, what? Oh, yeah, good,
That's awesome.
good. For once,
No.
today.
No, you're absolutely right. Those are all intangibles that you can't quantify, and you can't just look to see if there's glitches. You can't just look to see what objections are made. Analogizing this to the right of confrontation, courts have held that video confrontation is not the same.
But I know you're going into all the different dynamics.
Yeah.
There's a lot of them, and I've tried
Yeah.
to talk about them. It's very difficult to sit here and detail when I've written these statements, all the different ways that it's important to have people in court. And I'm just trying to get you to talk about the big picture.
Yeah.
About having everybody's focus.
Yeah.
Isn't the defendant entitled to have the court's sole focus be on that case at that moment in time? And everybody, the prosecutors, the spectators, the victim, the clerk, everybody fully absorbed into that moment in that proceeding.
You're absolutely correct, and it's a vast understatement to call it a ceremony but I can't think of a better word for it, a more appropriate word, because it's not just a ceremony. It's a valuable ceremony. It's a valuable proceeding to both the integrity of the system and to the defendant himself and to the victim.
I just think you can't understate the notion that if I'm looking at you on this screen, there are distractions. People click off on the internet. They put their phone in front of the screen and they start playing video games. People do all kinds, they text their friends. They do all kinds of stuff, and that's multiplied by all the participants in the proceeding. And not every judge, some judges sit on the bench and read the newspaper, but it's a lot harder to do that in a public courtroom than it is to sit at home and do that when you're doing things virtually. And that's one of the things I find so highly upsetting, I think, about this, is that we're not putting that pressure on all the participants in the court proceeding to give us their entire focus. If I'm the judge and the lawyer's talking to somebody else or looking off or laughing, you get offended by that. Not just because it's disrespectful, but because everybody's not paying attention. And I think that meaningfully subtracts from the hearing, the quality of the hearing.
And imagine the defendant in a jail cell watching it and wondering what's being said about him, what glances are being made, what kind of smirk, what that smirk means. Are there snide remarks being made about him?
I can't imagine, your children being taken away or you being sentenced off to prison on the computer screen, like you said, when you're feeling like you didn't even get a fair hearing or everybody to pay attention to you for even that moment.
And that goes to the second, sort of in the third aspects of structural error that Davis and Weaver talk about, right? It's fundamentally unfair, and it's difficult to quantify all the different ways, right? Demeanor is important to the confrontation clause, and demeanor is reduced when it's through video. But a judge does more when he's looking at a defendant at sentencing. He's trying to judge his worth as a person. He's trying to view him and to see if he's contrite, to see if he's remorseful, to see if he's sincere. Does he walk into the courtroom?
And it's in the crucible of the hearing. How does that person respond in that moment when confronted by the judge and the prosecutor and the victim?
Does he act cocky? Does he act arrogant? Does he
All
take
in
the
that
proceedings
moment, which
seriously?
Right. Happens every day in courts all around the country.
So,
The two of you are ready to hold hands and sing Kumbaya.
Which
maybe
you
I'm
can only do in
nostalgic.
person and not
Yeah.
on
That's
video.
true.
I'm
That's true.
nostalgic about my old job, but those to me were the most meaningful days in court, and we've sort of zeroed those out, you know, we're just like, nah, we moved on from that. And I think, to me, the things I got the most fulfillment out of as a trial judge, we don't bother with anymore.
I have to say that the prosecution, including the author of the Pam amicus, agrees with a lot of those concepts. A lot of what they have to say is directed at the victim's rights, but a lot of what they said about the victims
Pam was
applies.
very strong,
Yeah.
supporting in-court
Yeah.
hearings for criminal cases.
We have also zeroed out your rebuttal.
I incorporate by reference the arguments made by Justice Viviano.
Those aren't arguments, they're questions, but they're lengthy ones, with
Thank
a
you.
lot of hypotheticals. And
Thank
life-
you. Does any-
and
does it-
informed
does
by
it-
life experience.
Pardon me?
And informed by life experience.
Thank you. We'd ask that you reverse and adopt our rule of structural or automatic reversal there. Thank you.
Thank you.
Still morning. Good morning to the court. Amanda Smith. I'm here as a special assistant Emmett County prosecuting attorney, and I'm here as the plaintiff appellee in this matter for this case, People versus Enciso. So the court is
So
very.
I know you get free fire zone, but
I'll waive it.
I'm used to seeing you here for Wayne County. You're Emmett? Am I wrong?
Pardon me?
Don't you usually come in for Wayne County?
I was sworn in as a special assistant prosecuting attorney for Emmett County.
Okay, got
Um,
it.
I expressed a lot of interest in this MOA. Word got back to the Attorney General's office. Next thing you know, Eric Restuccia's calling me on the phone. Would you like to do this villa? I agree, and here we are today.
Got it.
So
right.
the elected prosecutor was more than happy to have us kind of help them out in this case.
Counsel, good morning.
Good morning.
Isn't there something, isn't there really just something critical about doing proceedings in person? Doesn't it really go to the essence, like, it just goes to that nature of how things are presented, the emotions, the feelings, the expressions, that are just simply found only and experienced only in an in-person environment?
Yes, I mean, the people don't disagree, and I don't really disagree, Mr. Mittlestat, that there is some commonality between the briefing and this case. Sentencing is a critical stage of the proceedings, and absolutely an in-person proceeding does feel very different and, is very different than proceedings on video. I mean, this is my first time here since 2019.
Right.
Feels very different than shouting into a laptop, in 2019, a year ago, today, when I did Tyler
Counsel,
Tate.
I could I see it from this perspective. So during the pandemic, when things were done by Zoom, a person who was blind really couldn't participate. Someone had to sit next to you. They
Right.
had to kind of assist you. And I can only imagine, and that's just for your kind of basic daily activities, but I can only imagine that notion that your entire life, your freedom, your liberty, your family, everything is on the line at that moment, at that time. And you just feel that sense of paralyzation because everybody else is in the courtroom, but you're not. And so you're just, you have that sense of isolation that can be very all-powering. And how do you think that factors into the entire process and procedure?
Well, I think the fundamental core of that question is it error
Yes.
to sentence on video? And in this case, this is a man out of time case. This is a 2017 Polycom sentencing case, and Polycom is not the norm. So we have to look at what happened in August of 2017 when this case was before the trial court for sentencing. And first half of my brief talks a lot about, was there even error in this case? Because you as a defendant can waive your fundamental constitutional rights, and there is a strong suggestion here that if there was a remand, we could develop a record and prove to the new jurist in that county that Mr. Enciso did waive his fundamental right to be physically present.
Why wasn't that on the record?
Oh, Justice Clement, working every day in trial courtrooms, the things that don't make it on the record, I mean, it's as an appellate attorney, and then also when I go down to the trial courtroom, it is disheartening. I gave an example in the first half of my brief of you can have a full conversation between counsel, maybe you met in chambers, everyone agrees, yes, the defendant is in the jail right now, but he is completely fine with being on video. everyone, starts up the hearing, but before they call the case on the record, you have that conversation. Yes, the defendant says, I agree to appear on video, but it just never makes it on the record. That happens all the time. Simple mistake.
What type of waiver do you think would be appropriate for waiver of this right?
So I think Johnson versus Zerfs, which I'm probably not saying that right, 1934 U.S. Supreme Court talked about the lack of a record for a violation of a defendant's right to counsel, which is a core, structural error type of right. And because there was no record on whether he had waived that right, they remanded it for an evidentiary hearing, and it was defendant's burden to show by preponderance that he had not waived that right. If he had waived it, no problem, no error, because you can waive a fundamental constitutional right.
The
If
question
he had
is,
not
though,
waived it,
when you waive counsel, you have to be given some additional advice by the court or by your attorney in court on the record about the possible negative ramifications of that, about
like the court rule
court
and
procedure
colloquy.
and so forth, the
Right.
rules of evidence, and that's my question to you, because here we have a situation where, this is very interesting to me. A lot of people in the Zoom debate come at it from different perspectives. Sometimes lawyers really like Zoom because now I can handle 4 or 5 matters
Yes.
in the morning. Now, it doesn't really, and a lot of times doesn't really help or improve their representation, right? Because now they're distracted and
They could be
they haven't communicated
driving.
with the client.
I've
You
seen it
probably had that in your own experience, because I know the prosecutors are very frustrated with this as well. At least I've heard from a lot of them. I say that to say, and there's one other dynamic again here. You have a defendant who, most of the time, or at least some of the time, they haven't been through this before. And so they don't know how it's gonna unfold and whether it would be better to be with the lawyer or not. So if you have lawyers who would prefer not to be able to Zoom in, for example, and the client's in jail, shouldn't there be some informed waiver? Shouldn't there be some information provided to the defendant about how this is gonna play out? And if you're not in the same room with your lawyer, you're not gonna be able to communicate in real time like everyone else used to be able to do, and other people who appear in court, for example, or should it be up to the defendant to sort of, him or her, to be able to know in the future the ways in which this is gonna possibly negatively impact my case?
So I guess I think about that question in the context of we, under Strickland, assume counsel's competence. And defense counsel in this case has never been alleged to have been ineffective in any way. So I'm going to assume that Mr. Lyons, defense counsel, informed his client of his right to presence. That's an assumption I get to make under Strickland. That
But we
he
don't
was-
assume that on the right to counsel, right? We have more of an informed waiver when you want to proceed and represent yourself, right? You're given more instruction.
So the requirement that you have an on-the-record waiver for right to counsel, that I know at least is memorialized in the court rule. If you, as a defendant, exercise your right to remain silent at trial, there is no requirement that waiver be put on the record. You assume counsel advises client and he's exercising that right. So not all rights must be.
I don't know any judge who doesn't at least ask the defendant to stand up and say that.
That's to make a
On the
really good
record.
record. Probably the appellate department was just like, please, please make this record. But the U.S. Supreme Court has said you do not need to have it on the record. And in the oral argument in the Court of Appeals in this case, Judge Letica and
So
Judge.
it's enough if the defendant the question on the record is, do you waive your right to be present at sentencing? Yes, I do. Okay, and then move on. That's enough?
That's how I see a lot of the trial court judges do it, and I would be very afraid if this court thought that was insufficient because
You would be very what?
if you thought that was insufficient, that inquiry, the tsunami of cases coming back would be.
And that's
would be a lot.
do you know how long courts have used Polycom?
Well, the court rule was from 2006, and then it was modified, I think, in 2015, and the modification between those 2 years was really not insubstantial. Polycom was used, pretty consistently until we started getting into Zoom, which I only really recall courts using Zoom in 2020. I could be wrong on that. Maybe
So the
they used it
notion
before.
of using some sort of video mechanism is not a new one.
Not completely new. Zoom is really different, though. And I think one of the questions about, how the defendant appears on the screen and people being distracted and all that, you didn't have that with Polycom. Polycom was really clunky. I mean, I recall we would do hearings and literally we'd have a television screen in a back room and the defense attorney would go back there, we'd close the door and they would just be shouting into a television screen because that's just kind of how it was set up. So the other distractions.
But people did sentencings by Polycom.
Well, misdemeanor sentencings are in that court rule and they have been in the
I
court rule
should
since the
clarify,
beginning.
people who waived could do sentencings by Polycom.
You know, I don't disagree that when you look at that court rule, it really doesn't seem like it's set up to contemplate felony sentencings. It
Okay.
really doesn't, because it says defendant is either in the courtroom or waived his right to be present. That's fine. It says that you can use this video to take testimony. Well, allocution's not testimony, victim impact statements aren't testimony. So you're kind of like, what is that rule for? It's kind of like, it's a little odd.
Can I ask you a little different question? This happens a lot, okay? Does that make it right? So it happens all the time, so, maybe we as a court would say, well, this is how it's been done up until now, but we might, by rule, change it going forward. So I agree with you, there's been a deluge of cases and Zoom hearings, and everybody's trying to figure out what to do and how to proceed with their dockets. That doesn't, because people are surviving, that doesn't make it right, does it?
I'm not saying it makes it right. My hesitation and my concern is that if the court has the defendant on the record and asks him directly, you know you have a right to be here, are you waiving that right to proceed on Zoom? I hear judges say that a lot. The defendant says yes. I think your question was, is that sufficient or that may not be sufficient?
Right, I have no doubt that it happens all the time.
Right.
I tend to think that Zoom, contrary to all the PR we hear, isn't making things more efficient, because now courts are running on two systems. They're doing some hearings in person and some on Zoom, and so courts are really struggling to keep up. So of course they're having to cut corners, but it's sort of, to me, like the argument that the pandemic, the emergency sort of should change the way we do court, and sort of defendants had discounted rights during the pandemic, and after the pandemic we can go back to having you have all your statutory and constitutional rights, but during the pandemic, you get sort of a discounted version. I have a hard time buying into that, because
Oh, yep,
you're
and
not getting a discount on your sentence, right? You're still being deprived of your liberty.
And I've read, the information you've generated, and Justice Branson as well on Zoom. I'm familiar with your position on that. This is not a pandemic case. This is not a Zoom case. So I want to put a pin in that for a quick second, because I really want to just crystallize the idea of structural error. And really, when I read my brief last night, I kind of thought to myself, I wrote 23,000 words, and I could have just said this one thing, just the arrow getting right to the heart of the case. Let's start at the top. People versus Anderson, 1994, this court said, when you look at a violation of federal law, the Constitution, as is alleged here, you looked at federal precedent and the harmless error rule if it's preserved. U.S. Supreme Court has said for decades that most constitutional errors can be harmless. If the defendant had counsel and an impartial adjudicator, there is a strong presumption that any other constitutional error is subject to harmless error review. And the U.S. Supreme Court has found structural error subject to automatic reversal in a very limited class of cases. And this is the most important point. U.S. Supreme Court takes a categorical approach to structural error. It either is or it isn't. That alone is something to really stop here and focus on for a moment. Because the idea that the U.S. Supreme Court has in Russian v. Spain and Snyder versus Massachusetts said that the violation of right to presence at trial is subject to harmless error review means that this court cannot find or think that the U.S. Supreme Court would find a violation of right to presence at sentencing to be structural error. Now, that doesn't mean, because if it was preserved, it's reviewed for harmless error under Chapman versus California, that a defendant couldn't win, because absolutely you could win under harmless error, even if you're appearing on video at a Zoom proceeding at sentencing. And I put a lot of million examples, probably too many examples, in my brief of all the different ways Zoom hearings can go awry. So the idea that this court would apply regular four-part Koreans and look to have a defendant prove prejudice is not a futile endeavor. Absolutely, with the record to support the idea that the technology didn't work, that due to a disability, defendant couldn't participate, defendant can win under prong 3 of Koreans.
What do you make of the interplay, the exchange I had with opposing counsel about, and he brought up the point about the judge looking the defendant in the eye, and I raised the point about the defendant being entitled to the focus of all the participants at that moment in time? Am I just making things up, or is that what happens in court?
No, that is what happens in court, and I would submit that's exactly what happened here. This hearing's at 2:30 in the afternoon in front of the trial court. It was a 40-page sentencing transcript. There's no indication that anyone's eyes were on anyone other than the defendant and the importance of this proceeding. This was an extremely emotional, important public case that happened. This was a serious case. You could tell the judge treated it seriously. And again, it's pre-pandemic.
And I should
Nobody's
be-
in a car driving around.
I should be careful to say that I'm not alleging that any of the participants in this particular case
Mm-hmm.
did anything other than their best. I don't have any reason to believe that.
Right.
The point is, the way these hearings unfold, and we're thinking about, we're thinking about all the cases to come,
Right.
and the way court should be conducted
Right.
in the future. But you're not really, I mean, do you seriously contend the quality of the hearing is not diminished when it's on Zoom? It's not different in some meaningful way, and, the judge doesn't have to look the defendant in the eye and the victims? I mean, Pam wrote at length about how important it was for victims psychologically to be able to confront the defendant during the sentencing and say what they have to say in the presence of the defendant at sentencing, and the constitutional and psychological implications of that. Are those things not meaningful?
Nothing I have said here today suggests that that's not meaningful, but the question under this type of alleged error is, did defendant get the due process under the 14th Amendment? And you look at the entire record, and you look at whether or not he had a fair opportunity to present his case to the judge in support of the sentence that he wanted. And if he wanted to be there, he could have told the court he wanted to be there. Failing to object gets us into careens. His objection would have led to a different in-person result, absolutely. And that's all defendants have to do, is ask to be there in person. I'm out of time. I know it's the last case of the morning, so I don't know if there are any other questions. Okay.
I don't see any. Thank you
Thank
very
you so
much.
much.
The case will be submitted.